Hi, my name's Jennifer McGuinness and I'm a partner in the Contentious Probate team. If you've been left out of someone's will or do not benefit under the intestacy rules, or if you have received less than expected, you may be able to bring a claim under the Inheritance Act 1975. It's important to note that claims can only be brought where the person died living in England and Wales, and only certain categories of people can bring a claim, known as claimants, and this includes the deceased spouse or civil partner, the deceased former spouse or civil partner, but they must not have remarried, formed a new relationship or civil partnership, the deceased cohabitee if they were living in the same household for a period of at least 2 years immediately before the death, the deceased children, including adult children, and anyone who was treated as a deceased child, including stepchildren. Also, anyone being maintained by the deceased immediately before death. Anybody outside of these categories cannot bring a claim. Unless you were the deceased spouse or civil partner, you can only bring a claim for reasonable financial provision for your maintenance. This is not defined by the Act, but generally means what is necessary to meet daily living costs. It's not money to support a lavish lifestyle or a subsistence level lifestyle. The assessment is essentially what is needed to live on, which is decided on a case-by-case basis. This could be, for example, money to clear debts, to meet a monthly deficit, or the like. It may also include medical treatment and the cost of obtaining qualifications to improve your employment prospects. It's important to establish what you need from the estate at a very early stage in your claim. It's important to be aware at the outset that the Act cannot achieve equality of distribution of an estate or what you might perceive as being reasonable or fair. The position for spouses and civil partners is different. That starting point, and only the starting point for this category of claimant, is what they might have received had the marriage or partnership ended on divorce, as opposed to ending on death. There is much less emphasis on these claims on the maintenance needs. There are a number of other factors that the court takes into account when deciding a claim, and as such, solicitors must consider when assessing a claim all of these factors. They're commonly referred to as the Section 3 factors. They are the financial needs and resources which the claimant has now and in the future, the financial needs and resources which any claimant has now and in the future, the financial needs and resources which the beneficiaries have now and in the future, and any obligations and responsibilities that the deceased had towards the claimants and beneficiaries. Also, the size and nature of the deceased's estate is relevant, as is any physical or mental disability which the claimant or beneficiary may have. There's a catch-all clause that the court may also consider any other matter, including conduct of the claimant or any other person that the court may consider relevant. To prove that you have a claim, you will need to provide information and, importantly, documentation about your financial position. This will include details of your income, which includes any benefits you might receive, and your outgoings, as well as any debts and savings that you have. You will be expected to provide bank statements and other documentation to show your income and expenditure. If you own a property, information about the value of your home as well as any mortgage that you have will be relevant. If you're renting a property, details of your rental payments may be required, along with the terms of your tenancy agreement. If you are living with another person in your household, their financial information will also be relevant, and they will also be expected to provide documentation to confirm their position. If you think you may have a claim and wish us to assess it, we will initially provide you with a questionnaire to complete and discuss this with you. It is also helpful to have information about the deceased assets, liabilities, and whether they owned property. There is a time limit that applies to bringing claims of this nature. A claim must be lodged with the court within 6 months of the date of any grant of probate or grant of letters of administration, which is a document that the personal representative of an estate needs to obtain to deal with the deceased assets. If this date is missed, the claim can then only be brought with the court's permission. Sometimes there are good reasons why a claim has not been issued in time, and the court can give permission for late claims to proceed, but an application for permission must first be made, and that must be made as soon as possible and supported by evidence. If you believe you have a claim and are outside of that time limit, it is very important that you seek legal advice on an urgent basis. Many people do worry about the prospect of contested trial, and while some cases do proceed through to trial, it is a very small percentage, and it's very rare for a case of this nature to reach trial. Most cases are resolved by alternative dispute resolution. Alternative dispute resolution is where the parties try to resolve their disputes themselves rather than going through the court system. One of the most common and effective ways to resolve a claim is by the use of mediation, and we will advise you if this is appropriate for your claim. Many cases settle with the parties' representatives negotiating directly and making offers. A successful case, whether by settlement or court order, can take many different forms, such as receiving a lump sum payment, the transfer of a property, periodic payments from an estate for several years, or an interest in a particular property. The outcome of a case very much depends upon the individual circumstances. If you are successful in your claim, your opponent will normally be ordered to pay your legal costs, but this is not always guaranteed. If you are unsuccessful with a case, you will not receive anything from the estate, and if court proceedings have been issued, you would ordinarily be ordered to pay your opponent's costs unless the case is settled on different terms. It may be possible for a case of this nature to be funded by way of a no-win, no-fee agreement, and this is something that we will always consider when assessing a claim. I do hope this video has been helpful, and if you wish us to consider if you have a claim or if you wish to contest a claim being brought against an estate, please contact us on 0161 941 4000 or alternatively email us at lawyers@myerson.co.uk.